In this video, we will answer the question, what are 3 disadvantages to plea bargaining your criminal case in court? The answer to that question is coming right up. I am Steve Gustitis, and this is my channel, Gustitis Law. If you are new to the Gustitis Law community, I post weekly videos on how to effectively navigate the criminal justice system, on ways to defend criminal charges, and how to manage encounters that you may have with the police. I welcome comments and I welcome questions on my videos, and I promise to answer those and respond to those questions and comments in the comment section below. If you enjoy the video, consider giving it a thumbs up. And if you find the information here at Gustitis Law helpful to you, please consider subscribing to my channel. This is our second video in our series on the pros and the cons of plea bargaining your criminal case. Links to other videos in the series can be found in the description. Today we'll talk about and answer the question, what are 3 disadvantages to plea bargaining your criminal case? Remember that a plea bargain is an agreement that you have reached with the prosecutor. On the one hand, you agree to plead guilty to some type of criminal charge, and the prosecutor agrees to recommend a particular punishment outcome. The first disadvantage to resolving your case with a plea bargain is that you must waive your rights to defend yourself. You must waive your right to a jury trial. That means you must waive your right to force the prosecutor to prove that you're guilty beyond a reasonable doubt. You must waive your right to confront and cross-examine the witnesses that accuse you. And even most importantly, you must waive your right to remain silent, because during the plea bargaining process, you are typically required to make a confession in open court that you committed some type of crime. These are very, very heavy and important decisions that should never be made without the help of a skilled and experienced criminal defense lawyer. Following your confession in open court that you committed a crime, that may lead to your conviction. Of course, that depends on the agreement that you reached with the prosecutor on what the punishment result would be. But that brings us to our second point. The second disadvantage of plea bargaining a criminal case is the fact that you will need to endure some type of punishment. Whether that punishment be jail time, probation, community service hours, the payment of fines, court costs, fees. You may be required to take educational classes. You may be required to pay restitution. You may be required to submit to random urinalysis and other types of restrictive behavior that a probation department may implement in your case. But in any case, you will endure punishment. The third disadvantage of plea bargaining your criminal case is how it limits your right and ability to appeal. In most states, if the judge accepts the plea bargain recommendation made by the prosecutor in your case, you will have no right to appeal anything that occurred in the case, except possibly issues that were raised prior to the plea hearing and ruled upon by the court. If the judge does accept the plea bargain, again, no right to appeal. And there may be other disadvantages of plea bargaining depending upon your case in particular. Discuss those disadvantages with your criminal defense lawyer before you decide whether or not to reach an agreement with the prosecutor or to take your case to trial and force them to prove that you're guilty. I appreciate you spending time here at Gustitis Law and becoming a part of the Gustitis Law community. Again, if you have any questions, if you have any comments, please add those in the description below and I'll answer those as quickly as I can. If you like the video, please give it a thumbs up and possibly share it with others on your social media platforms. If you enjoy the content that you find here at my channel, please consider subscribing. I look forward to seeing you in my next video. Thank you very much.